Welcome to Notable Approvals. I am attorney Amanda Shaffer. Thank you for joining us. We have another exciting case to talk about today. So you don't miss another live. Don't forget to like us and follow us on Facebook and Instagram, Twitter, so you don't miss another live, as I said. But what I wanted to say is we're very close to having 1,000 likes. So maybe you can be that 1,000 person who likes us. So let's get to the case for today. Today's case is about a client who is a native and citizen of Mali. He entered the U.S. with a B-1 visitor visa in 1996. In 2007, he applied for asylum. He was placed into removal proceedings since he filed after the one-year filing deadline. And when he was in removal proceedings, he withdrew his asylum application and applied for cancellation of removal based on the extreme and unusual hardship that his U.S. citizen daughter would suffer if he were to be removed from the United States. We were not his attorney back then, but what ended up happening in that case is the immigration judge denied his cancellation of removal application, said that he did not prove the extreme and unusual hardship element. He then hired us after that denial, and we filed what's called a motion to reconsider. And basically, you file it with the same judge who made the initial decision, and you're asking the judge to reconsider her decision because she made a mistake. And in this case, the judge failed to list some of the evidence in the decision. So the judge said that he didn't submit evidence about that his daughter would have to return with him to his country if he had to return, that he financially supports her, and that he has like what his custody situation is, because his daughter, he lived in New York, his daughter actually lived in Michigan with the mom, his ex-wife. And when we took over the case, we reviewed the file, and it quickly became very clear that he in fact did submit this evidence. He submitted an affidavit from the mom. Mom had an order of removal, so the argument was that the daughter can't stay here with if he has to leave because mom technically shouldn't even be here. We showed that he's the financial support. We also showed that although mom has primary physical custody, dad has and exercises his visitation rights and is very much a big part of his daughter's life, like on holidays and whenever she's off of school, she's here in New York with him. So that's a very big error. And the judge, and actually surprisingly in this case, the Department of Homeland Security did not oppose the motion, and which normally they oppose anyway, or they'd say, well, even if the judge considered it, there's still not enough evidence. Because when you ask them to reconsider, you have to show the judge that her decision would have been different if she considered all the evidence. And if the judge didn't agree with us, we would then have to appeal it. But luckily, it didn't come to that. So the judge granted the motion, the stay of removal, which meant that he didn't have to worry about getting deported, then granted the motion to reconsider, put the case back on the calendar. And at that time, the question was, do we continue pursuing the cancellation case, or is there any other relief available now? Now, it turned out that his daughter that he was applying for aged out. And what that means is she turned 21 by the time everything finished with the case and the motion to reconsider. So she could no longer be a qualifying relative to say that, to base the extreme hardship on. However, because she's a U.S. citizen age 21 or older now, she was able to file for her father. And because she's an immediate relative, even though he was out of status and in removal proceedings, he was eligible for adjustment of status. So she applied for him. That was approved. And then back then, what the courts did is when you have a case with no criminal history, no serious issues, and the person's eligible for adjustment of status, they would terminate removal proceedings, and you would then go to your green card interview with USCIS and get your green card that way. That is exactly what happened in this case. The immigration judge terminated the proceedings. Our client went to his green card interview at USCIS, and now he has a green card. So it was a very interesting case to have. Whenever you see a judge's decision that doesn't reflect the evidence on the record, that always gives you a hint that there's something that can be done there. And it's not always so clear cut. Like I said, DHS, they usually reply. They usually oppose it in some way, shape, or form. But in this case, I mean, it was clear as day that the judge just kind of ignored half of the evidence. And when that and the judge acknowledged it, because judges don't like to be reversed on appeal, so you give them a chance to fix their mistakes. They're more than happy to when they're wrong. And everything worked out for this client. And I forgot exactly how many years he has before naturalization. I think he's close now to having enough years to naturalize. So he went from having an order of removal to having a green card, which is pretty cool. So that is all today for notable approvals. Like I said, like and follow us on Facebook and Instagram, Twitter, LinkedIn. See if you're the 1000th like on our Facebook page. And so you don't miss any more notable approvals, of course, or any other lives that we're going to be doing coming up. And we will be posting about some additional lives that we will be doing shortly on the website and on our social media. So make sure you take a look. Thank you all for watching and have a great day. Oh, and of course, our contact information has been scrolling across the bottom of the screen. So if you have any questions or need us, don't hesitate to contact us. We'll be happy to help.